All right, we've got a call-in question from Bonnie on the line. Bonnie, what's your question tonight?
Hey, Bonnie.
I wanted to make a change in a will, and I wanted to know if that's something I could do by typing it up and having it notarized, or do I have to go back to the attorney?
Hi, Bonnie. It's a great question, and I always recommend that you go back to an attorney, and this is why. I've had clients whose children bring me in a will that their mom or dad has modified, and it completely obliterated their wishes on the original will because they didn't quite know how to make the codicil, which is an addendum to the will, legally recognized in Alabama. I never recommend somebody make a change to their will because at your death, if it's not exactly what you intended to happen, it'll be too late. Yep. So that's my advice on that.
And all of this, if you have a will, it avoids probate court, right? Or does the will have to go through probate upon your death, or how does that work?
The will you still have to probate a will. The difference is when you die with a will, it goes through the probate court, but it's exactly what you want to happen. That's what the probate court does. It ensures that your wishes are carried out. If you die without a will, your assets still have to pass through probate, but then there's the law of intestacy, and it's divided in a certain way. Whether that's what you really wanted or not, the law says that's what will happen.
But either way, isn't probate court kind of a lengthy process? Probably faster if you have the will, but...
Well, it's not necessarily lengthy. If you have a will, we could get an estate opened in 2 to 3 weeks typically if all the heirs agree to having the estate opened. It can be lengthy, but it doesn't have to be. It just depends on if the parties are in agreement, if there's a valid will. Even if there's not a valid will, I think what you may be referring to, Andrea, is there's a 6-month claim periods of creditors. Every estate, whether there's a will or not, has to be opened. We have to publish 1 time a week for 3 weeks in a newspaper of general circulation in the county of the probate estate.
Citronelle call. I'll tell you about that later.
Exactly. And 6 months from the 3rd publication. So all the assets are more or less frozen during that time. So that's the length of time. So it's not a few week process, but it's not years.
But you can't really avoid that. You gotta.
No. That is the law, and that's to protect the heirs and the assets of the person who died.
Okay.
Yeah, the reference to Citronelle Call is a newspaper in Citronelle, and it's in this county, and that's the kind of the go-to paper that lawyers in Mobile County will, if they have anything they have to publish. Let's say you want a divorce and you don't know where your soon-to-be ex-wife is. You can absolutely file for divorce, but you have to serve her. Well, if you have that in place for, like Ruth just said, 3 consecutive weeks, then they're deemed to have been served, even though we all know they didn't see their name in the Citronelle Call. That's just legally required. And so whenever you're trying to bring somebody to the table, so to speak, that's what you have to do. A lot of times you have to publish what's going on.
Yeah, not everybody's serving the legal ads in the back of the paper.
Right.
All right, well, to ask a legal question of your own, you can call Bill right now, 251-463-0708. You can also send him a text at that same number, and you can visit lawcall.com/mobile to email us or watch clips of the show. Stay with us. We'll be right back after this break.